Welcome to The Law Beneath the Waves. In this new episode, we're going to dive into Southeast Asia with my dear colleague Tara Davenport. ASEAN sits at the crossroads of extraordinary resources, overlapping maritime claims, and a unique model of regional cooperation based on consultation and consensus. From continental shelves stretching beyond 200 nautical miles to pockets of seabed beyond national jurisdiction, the region raises critical questions. Who governs seabed spaces? What resources lie beneath them? And how do legal frameworks shape access and management of seabed resources? Across this new episode, we're going to explore how ASEAN states are positioning themselves in the emerging debates of deep sea mining, both within national jurisdiction and beyond national jurisdiction, including their positioning and role at the International Seabed Authority Council and their views on a potential deep sea mining moratorium beyond national jurisdiction. We examine the diverse position taken by ASEAN states, shaped by different economic ambition, social priorities, and environmental concern. By unpacking ASEAN distinctive governance model, its interaction like bodies such as APEC, COPSI, and PEMSI, and the future challenges of environmental protection, The Law Beneath the Waves reveal how law, geopolitics, and resources converge on the ocean floor of Southeast Asia. To have you today on the series of episodes The Law Beneath the Waves, and I'm especially happy because we're going to talk about a region that I love very much, Southeast Asia. So it's going to be the second episode dedicated to the regions that have been actually addressed in the book. And this episode is going to actually explain the great diversity, but also the specific characteristics of regional integration and management of the seabeds in the region of Southeast Asia. So as you explain it very well in your chapter, Southeast Asia is a vast sub-region of Asia that is characterized by the great diversity of languages, religion, but also legal systems and policies. And it has also exceptional resources. So resources like fishing, biodiversity, corals, but also oil and gas. And the regional integration of Southeast Asia is quite unique. It relies mainly on the emphasis of sovereignty and non-interferences, of course, but generally speaking, it's informal cooperation and flexible arrangements. If I compare it, for example, to Europe, where it's absolutely not the case like this. So the region that you've covered is composed of 10 countries: Brunei, Cambodia, Indonesia, Malaysia, Myanmar, Laos, the Philippines, Singapore, Thailand, and Vietnam.
And most, if I may interrupt you there, just to most recently, Timor-Leste has become a member of the Association of Southeast Asian Nations, which is the regional intergovernmental organization that is dominant in Southeast Asia. So I would also say that they're a member of ASEAN now.
Indeed, so 11 states now. So with this great diversity of states in terms of, economies and inhabitants and resources, one of the questions will be interesting for the audience will be actually to understand how vast the marine space of Southeast Asia is, especially in terms of seabed, so continental shelf, beyond and within national jurisdiction. Can you help us to understand a bit this, and maybe explain if there's any pockets of high seas also in Southeast Asia?
Thank you again, Virginie, for inviting me to be here today. It's been a great pleasure to contribute to the chapter in your volume, and I'm happy to talk about the chapter today. In relation to your question, I read a statistic somewhere saying that Southeast Asia's maritime spaces are greater than its land territory, right? So this really gives you an idea that Southeast Asia is predominantly and distinctively a maritime region. All Southeast Asian states are coastal states, except for Laos, which is landlocked. And two of these states, the Philippines and Indonesia, are the world's largest archipelagic states. the majority of Southeast Asian states, beginning from the 1960s, when they had sort of shed their colonial shackles, began to claim territorial seas, a 200 nautical mile exclusive economic zone, and sort of continental shelves. Singapore, where I'm from, is of course geographically disadvantaged, and due to its proximate location to Malaysia and Indonesia, has not actually enacted any maritime zone legislation, but it has stated that it will or can claim a 12 nautical mile territorial sea and a 200 nautical mile exclusive economic zone in certain areas. In relation to extended continental shelf, there are 6 Southeast Asian states, Brunei, Indonesia, Malaysia, Myanmar, Philippines, and Vietnam, that have made a total of 12 submissions to the Commission on the Limits of the Continental Shelf, the CLCS. And the CLCS has made recommendations on 2 of these submissions made by Indonesia and the Philippines. So when it comes to your question on areas beyond national jurisdiction and within national jurisdiction, I would say that there is some uncertainty in the boundary between the areas within national jurisdiction and beyond national jurisdiction because of the pending CLCS claims and the fact there has been no recommendation on 10 out of 12 of these claims. But there are deep seabed areas, I think in the Indian Ocean and the Pacific Ocean, which are clearly beyond the national jurisdiction of any Southeast Asian state. And I mean, I don't know whether you want me to get into this, but there is also a pocket of deep seabed in the South China Sea, potentially. That is uncertain due to several factors.
Yes, it's very interesting what you mentioned with the various claims that have been made with regards to the extended continental shelf. Also because the claim of Malaysia that was made in 2019 has actually received the longest list of opposition and comments from the neighboring states, with even the USA actually commenting 2 times, I think 2020 and more recently, and using the platform actually of the CLCS to actually oppose the China interpretation on the extension of the continental shelf. So it's interesting also because, as you mentioned, the pockets of high seas, especially in the South China Sea, where you have the different claims actually of extended continental shelf, mainly, a lot of claims have been blocked actually by the neighboring states, mainly China. And so we are in a situation where, without entering too much into the details, when a coastal state is actually, or a state is actually opposing the CLCS to move forward with the analysis and issuing a recommendation, it means that the whole process of the extension of the continental shelf is blocked, frozen, unless there's a boundary agreement. So with the current, I will say, politics in the South China Sea, potentially either it's going to remain blocked for a very, very long time, with potential bilateral agreements with some states, or it will just remain frozen, forever. What do you think about it? And so it will affect also the determination of the pockets of high sea of the area actually in the South China Sea as well.
Yes, I mean, for sure. I mean, I agree with your analysis completely. It is, I would say that it is, I think it would be very unlikely for the CLCS to consider some of the submissions, particularly those that encompass the seabed of the South China Sea, because of the various objections that have been made, not only by China. I think Philippines has also objected to Malaysia's submissions. So I don't think that the CLCS will feel that it is able to consider it. The only way, unless all the objecting states consent, and or unless there is a delimitation agreement, but because of the bilateral disputes, sovereignty, entitlement, as well as delimitation disputes, I also don't see there being a delimitation agreement or a maritime boundary agreement anytime in the future.
Of course.
So Yes, so there will be this sort of limbo. I mean, an interesting question is what happens if these Southeast Asian states start to actually explore and exploit the extended continental shelves, right? Because if you, without the final recommendation from the CLCS, I guess there's an argument that, of course, that such resources, such rights over the continental shelf are inherent.
Yeah.
That the CLCS does not recognize entitlement, right? So it would be interesting to see what happens then.
Yeah, indeed. But it's I'm looking forward to see how it's evolving. But basically, I mean, most specifically related to the South China Sea, it means for us lawyers that basically the limits of national jurisdiction will remain uncertain for a very long time. So it means that the management of activities need to operate in an environment where the limits are uncertain, with a lot of disputes, which makes it particularly difficult because we all know that when there are great resources, usually there are great conflicts and disputes.
Yes.
And at the same time, when there are great resources, there's a huge need of, environmental policy and environmental security actually to be developed and deployed, in this area. So this region is particularly interesting in terms of seabed management.
It is. Sorry, if I just also may clarify that there, in terms of the existence of a pocket of, deep seabed in the South China Sea, if one accepts the findings of the arbitral tribunal in the South China Sea arbitration, which only afforded the high tide features in the Spratly Islands, a 12 nautical mile territorial sea. On that basis, if you proceed on that basis, you would say that there is a pocket of high seas. Yes, but if China has rejected that award, and if you go along China's interpretation, there is no pocket of high seas in the South China Sea.
So very interesting. The South China Sea for many is actually known for, as I mentioned, exceptional resources, mainly in fisheries, but there's also a lot of oil and gas. And when we talk about deep sea mining, so deep sea mining, it's usually mining that happens at more than 200 meter depth. We're not talking about oil and gas. We're talking usually about the three main mineral resources that we talked about, in different episodes. Do you have any knowledge of the existence of these resources in the region, generally speaking, and in the South China Sea?
Yeah, it's a very interesting question, and when I did the chapter, I had looked into it, and just also recently in preparation for this podcast, but. I think, I can't say for sure, but while there is a lot of data on terrestrial minerals in the region, seabed minerals data in maritime areas within national jurisdiction and beyond national jurisdiction, I would say is quite sparse. I'm not sure that states have, they may have, unilaterally conducted sort of surveys and so forth and may have a better idea, but publicly available statistics have not been available on this particular, the availability of deep seabed minerals. I've recently read some reports saying that the region's deep sea is thought to hold significant deposits of nodules, cobalt-rich crusts, and sulfides. But I can't find the original reports, verifying this or substantiating this.
Of course.
Yeah, I did read some reports of China having done some exploration of nodules, in the South China Sea. But again, I think the information is not 100% clear.
Yeah. Do you think it could be also the case that due to the disputes, this type of knowledge is not publicly available?
Could very well be.
Yeah, to actually avoid further complications. Because, all these resources, and you see it's actually with the, the dynamics in the extended continental shelf submission. There's a lot of geopolitics involved in deep sea mining. And it's not only linked to mineral resources, because it could be also securing sovereign rights, the extent of the sovereign rights. It could be, securing a space where you can actually develop your own environmental policy. So it's more complex than just minerals, but minerals, of course, play a very important role. And we all know that usually resources are very much protected by states. So it could be one of the reasons potentially. Very interesting. So we've seen actually in Southeast Asia that Singapore is quite advanced in terms of technology and has, through the years, expressed a keen interest in exploration and potentially exploitation, because exploration, it has actually contracts with the ISA. But what about the other Southeast Asian states? And do you think, it's a question that I like to ask actually to all authors, because I find it really interesting. Do you think that the various claims on the extension of the continental shelf are linked to potential resources exploitation, or just securing, as I mentioned, the limits of national jurisdiction?
It's an interesting question. I think within Southeast Asia, I believe that only Malaysia and Indonesia have expressed an interest in deep seabed mining within their national jurisdictions. And I actually, I think that quite recently, Indonesia has adopted or is considering a law on seabed mining. With regards to with Singapore, as you said, Singapore is the only Southeast Asian state which has a license to explore the Clarion-Clipperton zone. It doesn't have a license, it is a sponsoring state, of a Singapore incorporated company. And I'm not sure, I'm really not sure about whether Indonesia and Malaysia are also interested in exploring resources or exploiting resources in the area. Indonesia is, of course, also a land-based producer and is part of the council group that are land-based producers. So I really am not certain about what their interest in seabed mining beyond national jurisdiction would be. But we are all in Southeast Asia. We are all developing economies. I mean, Singapore is technically a developing state, and they may not have the financial capabilities or technical capabilities, to do such deep seabed mining.
And potentially these two countries might be more interested in the development of the enterprise rather than sponsoring directly, or depending on the economic capabilities. We see that at the ISA, the enterprise is starting very slowly.
Yes.
So I think it will be interesting to see in the years to come, how much it's really supporting developing states and basically the implementation of the common heritage of mankind.
I'm not actually sure, and I know we've I did a little bit, I didn't mention this in my chapter, but I'm not actually sure whether they are interested or what their position is on the enterprise. I mean, I believe the African and Caribbean states have been very supportive of the enterprise. I am not sure about I just did a little look just now, and I could not find anything that would suggest that they are against or for the enterprise.
Interesting. So something else to follow up. And what you mentioned also with regards to the position of Singapore, in the Council of the ISA, the rest of Southeast Asian states usually belong to Group E, which is not the same one. So maybe you can explain a little bit, the difference between the groups, and within Group E of the ISA, which has, of course, a vote that is mixed with another chamber. We see that there's a lot of diversity in the position of these countries also with regards to deep sea mining, with country being, supportive of a moratorium, or others being unsupportive of a moratorium or oppose whatever you interpret, the scope of the moratorium. And we see that generally, Group A and Group B are more supportive of a non-moratorium. It doesn't mean that they don't want to implement the precautionary approach. Maybe we could dive a little bit into this. As you mentioned, the other states interested in deep sea mining, you couldn't find any information, about, their specific interest. Is it right? Yeah.
Yes, well, on the enterprise for sure. In relation to the moratorium, precautionary and/or precautionary pause, my inclination would be to say that they are either supportive or neutral. None of them have none of the Southeast Asian states have explicitly signed on to they're not part of the countries who have supported the moratorium or precautionary pause. And I think even from Singapore's perspective, I believe that they are the primary interest is to make sure the exploitation regulations are concluded.
Of course,
before anything happens, because I think that is what they believe the mandate of ISA is. So and I don't think I'm not sure that I would find it highly, although I can't say for sure, I would find it interesting to see whether other states Southeast Asian states have explicitly supported the moratorium. The only state that I would see potentially doing so is the Philippines, because it is, I can see maybe Philippines supporting it, but as I have said, I've not looked at their positions in the ISA debates, and that is actually another area of future research. I think maybe not me, but someone else would like to undertake.
I think what is interesting also when we talk about, the moratorium is that people usually fail to understand that the moratorium that is being that everyone talks about is only dealing with deep sea mining in the area, and it's not dealing with deep sea mining within national jurisdiction. So some states actually are supportive of, the moratorium in the area, but actually are still exploring and potentially exploiting within national jurisdiction. So there's a lot of it's more complex than just we have a moratorium and everything will be stopped. And I think what you mentioned also is really representative of the position of many countries, the importance of developing a very sound, solid exploitation code. Because if we have a very solid exploitation code, potentially we don't need the moratorium, because the screening will be made and anyway the precautionary approach will be implemented. So so that could explain also why certain countries, are not signing up for the moratorium, even though they have very high interest in, sustainability and protection of the marine environment.
Yes, agree. What is interesting to me is that what I see within the Southeast Asian region is actually, which I hadn't seen before, but much more advocacy from NGOs on deep seabed mining. Against deep seabed mining. So that has been interesting for me to see, that this is a topic that has actually engaged a lot of NGOs, environmental NGOs within the region.
Yes, indeed. It's the same in Europe, and I think, in Latin America as well. But that's why I thought it was really interesting also to clarify, the scope of the moratorium, because usually people who don't know anything about deep sea mining, they think, the moratorium will stop everything, when actually the moratorium has a very limited scope and is anyway subject to a vote of the council. And I think the vote could be very problematic to adopt the moratorium because of the way the chambers have been actually design. So anyway, that's another topic.
Yes, I know.
Very interesting. Now that we have actually, explained a bit the way Southeast Asian countries are positioned towards deep sea mining and how vast the marine space of Southeast Asia is. Maybe we can dive into, you know, the model of regional integration, because it's very specific to ASEAN. And maybe you could explain the main characteristic of the regional governance and how actually this regional governance is impacting or is affecting the management of the marine space generally, and more specifically for the seabed, knowing that, as we mentioned at the beginning, there are ongoing issues with the certainty of limits of national jurisdiction with regards to seabed in, I mean, mainly the South China Sea.
Yeah. Okay. No, I mean, that's a great question. And I would say that there are regional organizations and frameworks in, in Southeast Asia. It is not, I think I would say, it's very hard to compare it to the EU or even the Pacific Island states, which seem to be very sort of cohesive and unified on certain issues.
It's something that we actually realized when we did the book is no regional model could be compared to another one. So that makes it even more interesting, because, you know, the dynamics between the countries are very different. The type of integration is different. It's very much based on culture.
Yes.
So that's why I actually asked the question to all the regions that have been covered in the book, so people can understand the specifics and why actually the characteristic of regional governance are very specific and tailored to each single region.
Okay, yeah, I mean, I think generally there are sort of 4 regional frameworks, I would say, that could potentially not regulate seabed mining, but could address seabed mining. And they all have varying degrees of formalization and institutionalization. The premier regional intergovernmental organization is ASEAN, which, as you talked about earlier, consists of the 11 ASEAN member states. And this is followed by other sort of regional, I would say, regional cooperation frameworks, right, such as the Asia-Pacific Economic Cooperation Forum, APEC, right?
APEC.
APEC, and then the coordinating body of the Seas of East Asia, which is COBSEA. So a lot of acronyms here. And partnerships in environmental management for the Seas of East Asia, which is PEMSEA. But ASEAN, I would say, is the most formalized. ASEAN started off as a very loose and informal organization, right? Really forged in, the 1960s, in the wake of, communism and the Cold War, right? And it was really based very much on this idea, as you also mentioned, on non-interference, sovereignty, right? And coming cooperation, but very much based on consultation and consensus, right? Yeah. So in more recent years, it has attempted to concretize its legal and institutional decision-making procedures. Really, that started with, a major milestone was the adoption of the ASEAN Charter. But even then, decision-making is very much characterized by the practice of consultation and consensus, which we refer to here as the ASEAN way. Right, so it has to be basically consensus by all now 11 ASEAN member states. So sometimes it is difficult to get that sort of level of consensus, amongst all of them. So I think I would say ASEAN outputs have focused more. They adopt a wide range of instruments, right? They're only of course, there are treaties or ASEAN-based treaties with binding legal obligations, but there is also I would say, a plethora of soft law instruments, right? Ranging from blueprints and work plans, right? And there's generally, I guess I would say, not that much guidance on how these instruments are concluded and their binding legal effect, right? But that is not to say that these instruments don't have any impact, right? I think they are very important to, particularly for the bureaucracies, the national governments, the various agencies, to sort of nudge them. They provide a framework and they do
a direction, a vision.
Yes, a direction, a vision, right? And the national governments and the various ASEAN sectoral bodies really do try to implement these visions or all these blueprints. So it is a different way of working, perhaps very much reliant on more soft law instruments and consensus. But I would say it's still effective, right? Particularly also, I would say, with economic integration.
Yeah.
So that I would say that is the characteristics, right? More loose, more informal, more discussion, consultation basis. I would say an emphasis more on sort of programs and work plans and soft law instruments.
And how do you, I mean, on your own interpretation, of course, how do you assess the, let's say, the efficiency or the impact of this model of governance on the management of the marine environment and potentially the seabed? Do you see it as very efficient, for example, because it's really based on consensus and consultation, and so you really need to find, the low-hanging fruits binding everyone, or do you find it not enough effective because you can't go further? It takes too long time, and it faces difficulties in meeting the different challenges.
Yeah. I mean, these are very, great points. And I think there's no sort of right or wrong answer. Yes, I mean, there are definitely challenges. I think in particular with maritime spaces, and of course you always have the specter of the South China Sea disputes looming, sort of underneath any sort of maritime cooperation between ASEAN states, because 6 of the ASEAN member states, I believe, are 5 or 6. 6 of them are claimant states. I think 5 maybe, sorry. And Indonesia is not a claimant state, but there's its areas also border the South China Sea, as is Singapore. So we are all I think the Southeast Asian countries are concerned about the impact of the South China Sea disputes and whatever that is concluded on maritime cooperation in the ASEAN, in the context of ASEAN, doesn't impact their claims in any way, or positions in any way. So, I mean, I think that it's a mixed bag. I think that this informal way of cooperating, as you said, it enables sort of the low-hanging fruits, and it does, it does serve as a forum for discussion, and I think sensitizes the various national agencies to different aspects of maritime management, but it is slow and very incremental. Right. Yeah. And I think also, as I explained in my chapter, but maybe changing a little bit, they tend to, I guess, ASEAN states, because we are developing, they tend to look at, the protection of the marine environment through a sustainable development lens, right? Focusing more on blue economy, right? But of course, part of that is the protection of the marine environment and conserving resources. Yeah, but I would say that in general, seabed mining has not really, to my, based on what I did a while ago and even now, has not really been a predominant focus of the regional frameworks, right? They seem to have dealt with it in a very sort of ad hoc. It's mentioned, right, in certain documents, certain frameworks, certain blueprints, but not deeply, sort of explored. And I would say that in terms of the marine environment, the priorities for ASEAN states seem to be more the marine plastic pollution, right? Yes. Rather than sort of deep seabed mining. And I think this is for various reasons, right? So it's basically, they're developing countries, right? They don't have the financial and technological capabilities to search for, explore, and exploit seabed minerals. There is also government officials sometimes lack awareness on seabed mining, right? Which means there are less opportunities for it to come up in any of these regional bodies. Yeah, and environmental priorities are really focused on climate change and, as I said, marine plastics, right? The fact it's not conducted yet the fact that seabed mining is not conducted yet on a large scale within national jurisdiction also means that it's not really become I would say, pressing priority for the various regional frameworks.
And it could be, I mean, I imagine with the exceptional biodiversity that the region has, it could be actually also that the region within national jurisdiction decides differently, that they can actually prioritize, even genetic resources exploitation or protection of the marine environment, for tourism, conservation. I mean, there's a lot of different ways to connect, I will say, seabed management to the water column, to the blue economy, and not just seabed mining.
Yes.
And with tourism being so important for Southeast Asia, I think it's important also to recall that, as we say, in law, we say like all the issues of the marine environment are interconnected, but all the sectors of the marine environment are interconnected as well.
Yes.
So yeah, it could be the example of a different priorities that could be set up in the future due to many different factors, as you explained, economic, financial capabilities, priorities, and so it's something actually we have to keep on looking on the developments that will be made in the years to come. I think it's a good way also to reach the end of the interview. What do you expect in the future? You mentioned in your chapter that it's a sentence that I really like. While the marine environment is important, ASEAN's record on the protection of the marine environment remains largely to be developed. When we talk about seabed mining and, for example, extension of the continental shelf, as you mentioned, we talk about the implementation of the sovereign rights of exploration and exploitation, but also the ability of coastal states to develop an environmental policy on their seabed within national jurisdiction. Do you have any insights on the state of development of this environmental policy? Generally speaking, coastal states have not developed a sound environmental policy for the seabed within national jurisdiction. But I think it's important. It's interesting actually to give perspectives when we talk about seabed mining. It's not about just developing the tools for seabed mining, but also what could be done on the seabed and what could be done to protect the marine environment, to develop other type of economic activities. Do you have any insights on what's happening or what to expect actually in ASEAN in the years to come?
Yeah, I mean, I wish I had a crystal ball. I mean, I think it's interesting that you say that generally speaking, you have found that coastal states tend to, I would say, across the board in different regions, neglect the environment of the continental shelf, right?
Yeah.
And of course, I mean, even within the law of the Sea Convention, there is not that much, on that. I would say, firstly, it would be interesting to see how the BBNJ agreement impacts the development of sort of future environmental policies, both on the part of individual countries as well as on a regional basis. I mean, I think 5 of the ASEAN member states have become parties or have ratified the BBNJ agreement, which is very promising. And so how this is going to interact with their sort of, I guess, interest in seabed mining in the future remains to be seen. I think there is generally quite a lot of interest in seabed activities on the part of Southeast Asian states. Vietnam is developing its offshore wind farms. As I said, Indonesia, Malaysia, and Vietnam, I think, have quite extensive oil and gas industries.
Indeed.
Right. It's just now a matter of, I think, I think individually they have made steps to develop some sort of environmental policies in relation to specific activities that take place in the seabed. I'm just not sure, and maybe there has been some developments also on an ASEAN basis. I think particularly for oil and gas and offshore wind activities. I'm just not sure how deep seabed mining is going to play into, seabed mining, both within and beyond national jurisdiction, is going to play into this. I think it will really depend on whether states such as Indonesia and Malaysia really, put their efforts into seabed mining. Right. So right now, a lot of emphasis is, as you said, is oil and gas, but also on carbon capture and storage. Right. So that has on offshore carbon capture and storage, and that has become also very much a pressing issue for the region.
Indeed, and a lot of technology, I mean, some of the technology is actually using storage in the seabed. So it's another way to use the seabed. Exactly. Yeah.
Yes, exactly.
Do you know if there's any, I mean, for example, in Singapore, because you know a bit more about Singapore, is there any definition or specific legislation dedicated to environmental damage that could be triggered in case of not just seabed mining, but like generally speaking, offshore farms or seabed storage, which could trigger actually this type of offense or criminal prosecution, depending on the damage.
It's a very interesting question, actually. I mean, I know Singapore has the deep seabed mining legislation, which will also which has provisions on, liabilities of contractors in relation to, activities in the area. In terms of other, I mean, the problem is that Singapore has a very small maritime space.
Yeah, of course.
Right. So, I mean, we definitely have, of course, oil pollution legislation, on compensation, the civil liability frameworks, but in terms of seabed activities, I'm not entirely sure. I have to confess, with the exception of what the Deep Seabed Mining Act in Singapore says.
Yeah, it's something also that I've realized throughout the book and the work we all did for the book is that this type of, I will say, essential in the toolkits of the lawyer is usually not existing in countries. So, or there's issues in the scope of application of, environmental damage that is not fitting with, deep sea minerals or deep sea environment. So yeah, it's always interesting to ask the question in case there's been some updates, but there's still a lot to do actually in terms of, I will say, just management of the seabed within national jurisdiction. Beyond national jurisdiction, I'm confident that the work of the ISA and the exploitation code is really going into a very good direction, because what they're doing at the moment is really modern, I will say, inserting a lot of new concepts and new considerations. And so I think, to my interpretation, that's why it's taking time, because there's a huge leap between the exploration code and the exploitation code. But states still have a lot of work to do in their own legislation within national jurisdiction.
Yes, for sure. I mean, I'm looking at the current draft of exploitation regulations. It's a lot. It's a lot. It's very comprehensive, very detailed. So what it will, and you're right, actually, national legislation, it will be interesting to see how that is implemented. But I guess I can ask you, do you think that they will finalize the exploitation regulations this year?
Difficult to say, because when you look at the draft, there's still a lot of work to be done. There's a lot of inconsistency. There's a lot of things to correct. And what I'm hoping is not, a political win, but a beautiful legal tool. So lawyer answer, I will say, I hope not. But I really hope actually the code to be like a sort of model, for not only seabed mining, but seabed management, because they'll, you know, the exploitation code also talk about restoration. So I think there's a lot of consideration that are being inserted into this code. And I'm actually expecting this code to be a model that could be used for the development of legislation within national jurisdiction.
Yeah.
So yeah, hopefully there will be interesting dynamics, you know, to
Yes.
look between what's happening beyond national jurisdiction that could inform within national jurisdiction in terms of consistency and alignment.
Yeah.
But, you know, politically speaking, everyone is hoping to have it wrap it up super quickly.
Yes.
But I know that sometimes it's a trap because, you know, when you wrap it up too quickly, you have like huge implementation issues.
Yeah.
So yeah, I don't know. I mean, for us, it's good because it could be a lot of work, you know,
Yes.
but for the sake of, you know, peaceful development of law and
Yeah.
activities, I will hope it will take the time necessary to have a very polished and beautiful code.
Yes,
What
fingers
do you think?
crossed. Yes, no, I mean, I completely agree with that. I think it's, yeah, you know, let's get it right, before we start anything, if we do have to start anything. So I think it is very important to spend some time on developing the exploitation regulations.
Yeah, indeed. Well, Sarah, thank you so much for your time.
Yes,
It was a
thank you,
pleasure to
Virginie. It was
discuss
lovely to
with
talk to
Sarah.
you. Yeah.
I'll
And
see you soon, and
yes.
I wish you a very nice first week of
Oh,
January.
thank you. Thank you so much. It was great to talk to you. See you
Bye
soon.
bye. See you soon.
Bye-bye.
Bye.